Types of courts in the UK. The UK court system is divided into three main tiers. Magistrates' courts. These are the lowest level of courts in the UK and deal with minor criminal offences. Crown courts. These courts deal with more serious criminal offences, as well as civil cases. High Court. This is the highest court in the UK and deals with the most serious criminal offences, as well as complex civil cases. The court process. The court process in the UK can be complex and lengthy. It is important to understand the different stages of the process so that you can prepare accordingly. The following is a general overview of the court process for a criminal case. 1. Investigation. The police will investigate the crime and gather evidence. 2. Charge. If the police have enough evidence, they will charge the suspect with the crime. 3. First appearance. The suspect will appear in court for a first appearance. At this hearing, the suspect will be informed of the charges against them and will be asked to enter a plea. 4. Pre-trial hearings. There may be a number of pre-trial hearings, such as case management hearings and plea hearings. 5. Trial. If the suspect pleads not guilty, the case will go to trial. At trial, the prosecution will present their evidence against the suspect. The defense will then present their evidence and make arguments about why the suspect is not guilty. 6. Sentencing. If the suspect is found guilty, they will be sentenced by the judge. The sentence will depend on the severity of the crime. Civil court proceedings. Civil court proceedings are generally less complex than criminal proceedings. The following is a general overview of the civil court process. 1. Claim. The claimant will issue a claim form to the defendant. The claim form will set out the claimant's claim against the defendant. 2. Defense. The defendant will have the opportunity to file a defense. The defense will set out the defendant's response to the claimant's claim. 3. Pre-trial hearings. There may be a number of pre-trial hearings, such as case management hearings and discovery hearings. 4. Trial. If the parties cannot settle their dispute, the case will go to trial. At trial, the parties will present their evidence and make arguments about why they should win the case. 5. Judgment. The judge will make a judgment in the case. The judgment will set out the judge's decision and will order the defendant to pay damages or take other action. Professional advice. If you are involved in a court case, it is advisable to seek professional advice from a lawyer. A lawyer can explain the court process to you and can help you to prepare your case.